so much for joining us today. And the topic is Protect and Grow Your Privately Held Company's Value, 12 Timely Ideas and Strategies. This is the second annual version of this webinar, so thank you so much for being a part of it. The idea, as you probably know, if you were with us last year, is to discuss on kind of a high-level basis 12 ideas that are contemporarily helpful to privately held companies of different stages of growth and a wide variety of industries. So it's a bit of a potpourri of legal ideas, and the goal is on things that might help a company protect and grow its value in the privately held space. So with that as an introduction, because there are 12 topics to go through, each of which could be an entire hour-long or so discussion in itself, I'm going to move fairly quickly and keep to the high-level topics, but I'll hopefully present some information that you'll find very useful. And please feel free to reach out afterwards with any questions or comments if you'd like to discuss any of the topics in more detail. So with that introduction, the first topic that I'd like to talk about, actually I would like to also add that today Amy Barnes and Alex Mirchuk will be joining the presentation at various points in time. Amy is of Reinhart's tax group, and Alex is in the firm's intellectual property group. And they will be providing some valuable insights to a couple of the topics that are going to involve some tax and intellectual property matters. So we'll look forward to them jumping in. And with that said, the first topic is discussing 338H10 election as a strategy for increasing value in merger and acquisition transaction settings. A lot of people know the concept of a 338H10 election, or I should say the phrase 338H10 election. It's a phrase that's actually rooted, of course, in a tax code section that has kind of infiltrated the popular vocabulary from a business perspective. So it sounds very technical and deep in the tax code, and it kind of is. So Section 338 is 338 of the Internal Revenue Code, and Section H10 is it's a lengthy provision, and those are the sections that apply in this situation. So trying to translate this tax concept into plain English, the election is a very powerful tool to help parties in a merger and acquisition situation obtain one of the rare win-win opportunities, so to speak, at the expense perhaps of the IRS. It's legal. Everything's up and up making the election. It's obviously provided by Congress to taxpayers. But in a situation where an S corporation is a potential target to a buyer corporation, this is where the 338H10 election can be useful. So the background of where this situation comes up is parties are negotiating and desire to structure an acquisition of an S corporation as a stock purchase. Now, one quick note is that oftentimes transactions will occur as an asset purchase, and if that's the case, there's no need for a 338H10 election. What would happen is the buyer would purchase the assets of the company, and then the tax treatment of the transaction would flow through, so to speak, the S corporation up to the owners of the company. Sometimes, though, for various reasons, legally, it's required or needed to structure the transaction as a stock purchase. For example, there may be contracts in the company that are hard to convey, and so, or there may be a large number of contracts, and so it may be needed or may be required that the transaction occur as a stock purchase format. In that case, the acquirer may desire the tax treatment that would occur normally with an asset sale, although the parties actually want to structure the transaction as a stock sale. That's the perfect time for the 338H10 election to be considered, because what a 338H10 election does is it actually treats a transaction as an asset sale for tax purposes only, whereby the target corporation would be treated as selling its assets to a subsidiary of the buyer and then liquidated. So the flow-through treatment would work on an as-if basis, as if it were an asset sale, even though legally it really is a stock sale for legal purposes. So the target would have its stock purchased by the buyer. A couple of quick notes as to when the election is available. The buyer must be a corporation for tax purposes. A buyer must acquire at least 80% of the target's voting power and equity value. and must be treated as acquiring those amounts by purchase. So oftentimes there will be a sale of 100% of the target stock, and it will be doable. So to summarize the benefits of how this helps protect and grow company value, and why it's a win-win. On the buyer's side, if it's a stock sale, the acquiring company would most likely have to capitalize the cost of the stock into the target's stock on its balance sheet. And that's typically a non-amortizable asset for tax purposes. Basically, translating that into plain English again, that means that the buyer would simply buy the stock of the target and hold it on its balance sheet, and that would be the end of the story. However, if the 338H10 election is made to the buyer, now it's treated as though it purchased all the assets of the target, and it can now take tax valuable amortization or depreciation deductions, most likely on the assets of the target going forward. Again, a lot of tax language here, but what that really translates to is a benefit of value to the acquiring corporation, because their cash flow is going to be improved. With more deduction after the transaction, that means more cash available for company operations and less cash going to the IRS sooner. From the target's perspective, and the reason this is a win-win, is the treatment is very similar to if it was an asset sale. There oftentimes will be some amount of higher taxes that the target shareholders have to pay as a result of the transaction, but the parties oftentimes will negotiate some kind of tax gross-up provision where the buyer will compensate target shareholders for making that election. So it's obviously an individual negotiation between the parties in a transactional setting, but oftentimes the mechanics are such that they can reach an agreement. So in summary, the 338H10 election is something that you should keep in mind if there's a merger and acquisition setting with a S corporation in particular, where there's a corporate buyer, and you may be able to create a large advantage that accrues to both parties' benefit, because the purchaser may be willing to pay more for the transaction with that election in place. So it can benefit everybody. Keeping on a quick pace, because time is quickly moving, on to our second topic, convertible bridge loans. As I mentioned, these topics are going to kind of bounce around from different types of companies, but privately held companies that are going to be primarily benefiting from these ideas. Now we're shifting from a company that's at the end of its life cycle, transitioning from a seller to a buyer, to all the way to the other end of the life spectrum, early stage kind of startup type companies that may be developing, for example, a technology or putting some research and development into something that's going to have tremendous upside potential, but at the early stage is still very hard to value the company's work. So the convertible bridge loan idea is a tool to help the company and an investor come to an agreement on terms for an investment in an early stage company. So to summarize the problem that comes up, a lot of times investors will be in discussions with early stage companies, but it's so early that the company doesn't have revenues yet, or it's still going through such a growth phase. It's unclear exactly how quickly the company is going to grow. And in that case, it might be difficult for the investor and the company to agree on a value for the company. They're going to need to know essentially the implied value of the company before the investment comes in, and then how much equity does the investor get in exchange for the investment. And it's a common issue that companies and investors have to deal with. Oftentimes they do resolve and negotiate a value, and they move forward with the investor coming in as an equity investor right away. But other times they use this convertible bridge loan structure to try to solve the problem by buying a little bit of time, essentially. So under this idea, what happens is the investor comes in not as an equity participant to start with, but as a lender. So this investment would be structured as a loan, and the investor would receive, obviously, a promissory note. However, the concept is that it's a bridge loan. What the parties fully intend is that this loan or this investment is going to be an equity investment by the end of the day. And what's going to happen is the company just needs a little more time to demonstrate its value so that the parties can agree on what the value would be. And in this case, what's occurring is the parties are kind of leveraging off of a subsequent investment from a subsequent investor to reach back and pin down what the value really should have been for the bridge loan at the earlier stage. So what will happen is when the company does experience some additional growth using the bridge loan funds for growth, it will then seek additional investment, And when that investment comes in, oftentimes as a preferred investment, the bridge loan will just automatically convert into the same type of equity that the subsequent round is presented. Now, in order to compensate the bridge loan investor for some additional risk that comes as a result of investing in the company at an earlier point in time, oftentimes they will negotiate that if the investment happens after some period of time or happens at all, it will be discounted. So the conversion ratio that the bridge loan investor would receive in order to determine the amount of equity that the bridge loan investor will receive is oftentimes discounted. So that they receive a little bit better deal than the subsequent investor because they were there earlier and absorbed a little bit more of the company's risk on the front. In the notes, and also this is a good opportunity for me to mention the business law blog that hopefully you're familiar with. This webinar is based on the business law blog. There's an example that will help you see some examples of how the parties could structure these terms just to further demonstrate the concept. So with the second topic now underway, moving to the third topic, Amy Barnes is going to join me to discuss this topic. I'm going to give a preliminary introduction, and then we'll have Amy join the conversation for a discussion of some of the tax ramifications. And this topic is sort of it's before the first topic where there's a 3/3 age 10 election at the end of a company's life cycle for the initial founding group. This is after a company's already probably experienced some growth and has maybe it's already gone through a bridge loan or something like that, but this is now a situation where you have an S corporation that wants to bring in a new round of investment itself. However, an S corporation is subject to significant limitations on who can be an owner. And in some cases, a corporation will want to be a C corporation for tax purposes in order to accommodate future investors, especially if they're going to be going through a venture capital type raise. Oftentimes, a company will want to be a C corporation right off the start. But if it is an S corporation, which is a flow-through entity for tax purposes, it's limited as to who it can have as an investor. So the issue that this third topic discusses is what happens if the parties all agree, including the investor, that it makes sense to keep the company as a flow-through entity, perhaps because this investment may be the final investment that the corporation needs to grow into a real operating company, and it will just continue to operate that way. But the investor is not eligible to be an S corporation shareholder, and that could happen for many reasons. The investor could be operating through a corporate form itself or an entity such as a limited liability company investment fund. If that's the case, then it's not eligible to be an S corporation investor. It could also be more likely that the investment itself will be some kind of preferred investment where the equity that the investor will be getting will have preferences vis-a-vis the common equity, and in that case, the company cannot issue that type of equity without losing its S corporation status. So there are some other reasons, but to try to continue the discussion, one idea is to have the S corporation basically try to maintain its S status with the existing shareholders, but to cause a new subsidiary company to be in place that operates as a limited liability company, treated as a partnership for tax purposes, and have the investor come into that entity as an investor. So the downside is that does complicate the capital structure a little bit. Now you'd have two entities, but you would have the investor now not compromising the primary company's ability to operate as a flow-through entity. So Amy, let's have a discussion about what that would look like. What mechanics would we implement to facilitate this structure?
Right. So the first step, the existing S corporation, the shareholders of the existing S corporation would contribute their shares to a new corporation. So we'll call that NewCo, which would be a holding company. That holding company would then own the operating company. So the first question, so that holding company, now does that have to file a new S election? It does not. The IRS has made it clear that the S election of the operating company will transfer up to that holding company. So they do not have to file their own S election form, although they will need a new EIN number. So now the operating company, there's probably a question, well, that's owned by a corporation. So you said, a corporation cannot be an eligible S corporation shareholder. What happens there is that new operating company or the existing operating company, a Q-sub election would be made for that company, which means that it would basically be a disregarded entity. So all the assets, all the holding company level. Now, for the new investors to come in, that operating company, as you said, needs to be an LLC. So there what would happen is we would convert the Q sub to an LLC. Now, the LLC at the time of the conversion would be a single-member LLC, so it would be wholly owned by the holding company, the NewCo. So for tax purposes, there shouldn't be any tax consequences. We're going from one form of disregarded entity to another form of a disregarded entity. Then we would have the new investor come into the LLC level, but when that new investor comes in, the LLC is no longer a single-member LLC. We now have more than one member, which means it would be treated as a partnership for tax purposes. So then the income and the operations of that LLC would flow through. It would be, the new investors that own the direct interest in the LLC, and then as well as the holding company, so the NewCo. That LLC would issue K-1s to report all the income gains, loss, etc. to those members. And then our holding company, our NewCo, would again issue a K-1 to those original S corporation shareholders.
Okay, so in summary, from a business perspective, the new investor comes in. New investor is happy because it's a preferred investment or whatever special terms are needed, and it'll own them in an LLC that will be a flow-through entity.
Right.
And then the old shareholders, quote unquote, the original founding shareholders, they're in the same place they would have been because they're still going to own stock directly in an S corporation, but it's going to flow through twice.
Right.
So they're going to have similar results, but the company obviously gets the benefit of the growth capital, and they can grow the business. Okay, well, thank you, Amy. That's a great summary. Obviously, we've had a few tax, some of the first three topics we've had here, we've had a lot of tax concepts. Amy's going to join us again for some more discussions when we talk about another entry that's going to be a little further into the presentation. But in order to keep things moving, let's go to the fourth concept, and this is a squeeze-out merger. What is a squeeze-out merger? It sounds interesting based on just the name. It sounds kind of diabolical. Somebody's going to get squeezed out of an investment. Well, what a squeeze-out merger involves is oftentimes you'll have a situation where a company may have grown, which is of course a good thing, and may have a widely dispersed capitalization chart with many diverse shareholders. Perhaps there were initial founding members, and then perhaps there were additional shareholders added as employees. Perhaps there was additional equity issued in some acquisition transactions where the company was growing by acquisition. Any number of reasons. There could be a situation where the company has a large number of shareholders, and at some point there may be a desire in some cases to try to simplify their capital chart, and perhaps there's a large number of very small shareholders, and the company just wants to narrow down the capital chart to a narrower group. There could be a number of different reasons for this, but any one could result in the need for structuring a squeeze-out merger. Basically, the concept of the squeeze-out merger is that if there's a majority shareholder of the target or the existing company who would have enough authority to cause the company to authorize the merger, or if there's a group of individuals that could pool their equity in order to have that situation occur, then what could happen is they could cause the company, or they could cause a new company to form a subsidiary that would merge into the old company, and the old company, quote unquote, would become a wholly owned subsidiary of the new company. Well, by operation of law, in many states, and this is a situation-specific structure. So you've always got to consider, by way of sort of a caveat here, you've always got to consider the exact facts that are at issue, and this doesn't always work in every situation. And some of it will depend on the state of the business in play. But assume, for example, this is a Wisconsin corporation. There is a mechanism under state law whereby you can cause the transaction to occur such that the shareholders of the target corporation, other than the controller or the controlling group, would essentially exchange their equity by operation of law in exchange for cash. And in order for this to work, the company has to obviously have access to cash resources in a significant enough amount to accomplish the squeeze-out. And there are some protections under the law that are intended to protect the minority shareholders from situations where the company would potentially be trying to buy out their stock with less than fair market value. So, for example, shareholders could potentially dissent shareholder and then have the right to have a court-appointed appraisal process occur where a court would help determine what fair market value is. But normally what will happen is the corporation itself, if implementing the squeeze-out transaction, would have an appraisal done, a third-party appraisal that kind of establishes with precision as much as possible what the value of the company's shares are, or a fairness opinion would be conducted. And the minority shareholders that are going to receive cash instead of equity in the transaction would receive cash in that amount. So it can be a win-win situation where the company now has a consolidated capital chart that's a little bit more contained and simpler, and the small shareholders may welcome an exit event where they get cash, because it may not be that the ownership in the company stock is a large part of their investment portfolio. So they may be very pleased with a cash buyout, and that is a mechanism whereby corporations can move forward with a cleaner balance sheet. That is the summary of the fourth topic. So switching gears now to our fifth topic, discussing LLC operating. We've been talking about corporations quite a bit for the first number of topics. Sometimes companies will be formed as limited liability companies. Oftentimes these companies will have a lot of flexibility under the law as to how to govern their operations. As a general rule, if there are multiple owners in a limited liability company, rather than a single owner, there's going to be some additional complexity that comes along with the flexibility under the law of being able to achieve specified results that the parties want. So oftentimes that additional complexity comes along in the form of an operating agreement. What an operating agreement is, first of all, is basically a contract. It's a contract between an LLC and its members. And it will do a number of things, and this presentation is intended to just summarize some of the main things that an operating agreement does and point out some of the flexibility that it has. With an operating agreement, one thing that the agreement will often do is sort of go over certain corporate formalities, legal formalities, I should say. Who's the registered agent, where's the registered office, things like that, setting out basically what the company does. Some of these are required because for the limited liability company format under the law, under state law, there's a little bit more fleshing out, I should say, of the relationship between the parties that occurs by contract as opposed to under the state statute. Another item that a limited liability company often will do is provide a series of capital accounts that track member contributions and distributions of cash. So these capital accounts will be fluctuating over time to reflect allocations of profits, losses, cash contributions, distributions between members. So each member theoretically has a capital account balance. And it's almost, sometimes I tell people, it's almost kind of like a checking account balance. It kind of tracks some of the value of what the member has in the company. And capital accounts are oftentimes included in operating agreements in order to stay consistent with some of the tax regulations requirements for how limited liability companies would work. Profits and losses are a concept under operating agreements that are different than cash distributions. So the main thing to remember here is that if a company has earnings, they may not distribute cash on those earnings. The company may reinvest those in company growth, but the profits and losses would still flow through to the members of the LLC, and those members would keep track of those profits and losses by adjusting the capital account. And it's a flow-through entity for tax purposes, so like an S corporation, which we discussed earlier, there would be taxes due at the member level for those flow-through profits. There should be a separate process for determining the timing and amount of cash distribution. So from a business perspective, the more important element of an operating agreement is going to be who gets the cash distributed and when and how, and who makes that decision. So there are many different flavors of how cash distributions can work, but oftentimes there will be tax distributions that will be mandatory that the company makes, and then discretionary distributions of cash and operations that may return cash sooner to one group than another group, or everybody equally. Here's where you have a lot of flexibility in an operating agreement. You can create a lot of different cash distribution scenarios to tailor it to the deals the parties have in place. And then on liquidation, there should be a description of how the cash is going to be distributed in a liquidation setting. Essentially, that may drive how cash distributions are made when a company is sold. A couple of other elements that an operating agreement should anticipate would be there typically are managers under state law required for limited liability companies. So the managers sometimes are given the titles of president or CEO or something like that, but technically the terminology from a legal perspective is we have a manager or a board of managers. We can do all sorts of things from a flexible nature again. We come up with kind of an advisory board concept or an actual voting board concept where multiple people have to agree before the board of managers acts as a group. Equity at the member level can be very flexible as well. We talked about some of the economic variations that can occur, but there can also be voting and non-voting flexibility. And so the operating agreement will typically need to provide how votes are going to be made. There can be different corporate or company level decisions that are made that require different levels of votes depending on what the situation is. So any number of variability there. Okay, I'm going to go ahead, because time is moving so quickly, we're going to move on to our fifth topic, and that is sixth topic, finance structures for growth-oriented business. I'm going to try to keep this topic fairly high level and contained. It's more of a quick general summary, and many people would know these kind of these elements, but just to flesh out. So depending on what type of life cycle the business is in, oftentimes there will be different types of finance structures that will be relevant to the business. A couple of common forms of financing will include senior debt, which would basically be bank debt. And the company would typically need to be in a more mature phase to have bank debt on its books, because the bank is obviously going to want to see collateral or earnings strength to make the loan on a secure basis. Mezzanine debt is kind of a middle, mezzanine means middle, and it's kind of a middle layer of debt. It has kind of a hybrid version between debt and equity. It has debt features to it, but it also has oftentimes an equity kicker, which will provide that if the company does really well, the mezzanine investor or lender, I should say, will get some additional payments to reflect a little bit greater risk that the mezzanine lender has. The mezzanine lender would be subordinate in priority to the senior lender, and so it's a little bit more risky position. But the terms of the deal, including perhaps the interest rate, would reflect a benefit of additional upside to reflect that risk. So it's very fair on both parties. And then there are private equity investments, which could be anything from a venture capital fund investing in a growth-oriented technology company that has demonstrated the ability to generate significant revenues in a test market or across the region, but needs a significant amount of additional equity to fuel growth, take it to the next level. Angel investors, which could be more along the lines of either angel funds or individuals that see a very early opportunity to invest in a company that they believe has great potential, but the company needs a smaller amount of funding, and so the angels invest in the company at an earlier stage, which obviously is extremely risky and will typically involve more equity for the angel investor. And then there are seed round investors. We talked about convertible bridge loans earlier. That would be an example of a seed round type investment where it's really early. Friends and family oftentimes would be in at that stage as well. It's called friends and family round. So a corporation or a company getting capital at that early stage will typically not be eligible for senior debt or mezzanine financing. Those would be much larger companies by the time they're eligible for that. Types of senior lending facilities, just a quick summary, revolving line of credit that the company can draw on typically for short-term working capital needs. Term loans and capital lease financing are other examples fall within that process. There can be some interesting side financing enhancers, industrial revenue bonds, tax-exempt bonds, and tax credit programs that may assist the company in having a stronger balance sheet, which could help strengthen your position for senior loan as well. Mezzanine investments often will be comprised of multiple hybrid components, as I mentioned earlier. A promissory note, which is subordinate to a senior lender, and possibly an equity warrant. A warrant would be the ability to purchase stock in the company with an exercise price, a small exercise price, that would basically operate as an equity kicker. So if the company does really well, the mezzanine lender will not only get repayment of the note with interest, but also participate in some of the increased equity value of the company. The next point is that some mezzanine lenders have different structures for how they prefer to receive the equity component, and there are ways to try to compensate the mezzanine lender fairly. Moving on, I think, to the next topic, we'll go to topic number 7, which is joint venture agreements. This topic is a very broad topic. In fact, even the term joint venture is kind of a wide term that often people use to describe different things. From a legal perspective, a joint venture can be thought of as kind of a narrow concept, where parties enter into a contractual relationship that are going to operate together, but there's not a separate legal entity formed. Most times, in my experience, when companies use the concept joint venture, they mean something much more broad than just the legal definition. What they mean is, in some way or another, two groups or companies are going to combine forces to work together to tap some new potential, and it can be as broad as that. Oftentimes, there will be a legal entity formed to house the new joint venture, like a limited liability company, or it may just be a contractual relationship. But whatever the term used, it involves some level of cooperation. So what are a few of the issues that come up with joint venture? Well, the parties are going to need to document the joint venture. Obviously, they're going to need to figure out how are they going to share profits and losses. And typically, the very nature of a joint venture suggests that there's going to be some unique synergies to the project. The parties that are involved are going to have different strengths they're going to bring to the table. Oftentimes, these will be two strategic companies. It could be one party is bringing cash and another is bringing property or something like that. It could be any different type of thing. But oftentimes, a joint venture is going to have a fair amount of complexity to how the arrangement is structured. Contributions of cash, property, services should be clearly defined, as well as distributions, to try to minimize any disruption or surprise that the parties may have in how the venture is going to operate. Some of the issues that I see as most critical to joint ventures, they require a lot of planning, and I think that they should be very well thought out by both parties, because they're basically the parties that are entering into a relationship. That's what it amounts to. And from a legal perspective, a lot of times I see the downside of what happens when the relationship doesn't go exactly as it was planned out. So that's where clear planning ahead of time, just to make sure everybody's in agreement on what will happen in different situations, can be very helpful to both parties or all parties involved in the venture. For example, there's a couple of issues to throw out there. What about a covenant not to compete? What if the parties to the joint venture do part ways? They should both be aware of what the restrictions are for them after that parting of ways, as to whether they can compete with, essentially the other party to the venture or the venture itself, if they're no longer involved. In some cases, there may need to be more or less restriction on that, depending on the business transaction that's that issue. Another issue might be what about working with customers before and after the venture? Is there a party that kind of operates in one particular territory geographically, and another party that operates in another one, and they're going to come together to a joint venture? But what if the venture is terminated? Then can one go into the other's territory and continue to operate that? Those types of questions have to be addressed by the joint venture agreement, so that the parties are very clear as to what can and can't happen after the venture. Also, what about confidential information? It can be very sensitive. If the parties are going to combine operations for a joint venture, they should be very comfortable understanding exactly what information they're going to be sharing, what information they'll be receiving, and then what sensitivity that access to information from the other parties would have after the venture completes its course, if it does. So obviously there's some element there of how committed are the parties to the venture. Do they want to kind of have a full and complete commitment to sharing information and operations and customers, all that kind of thing, or do they want to put some boundaries around it to start with and maybe ease into it a bit and have a gradual increase as things develop under the venture to help them understand how to achieve success under the venture? Finally, business opportunities is another thing that I often discuss with clients regarding joint ventures. What happens if a great opportunity comes up and one of the parties to the venture didn't anticipate this would come along, and they would kind of like to just have this opportunity for themselves because it might be a different nature of what was originally anticipated, but it has some overlap with what the joint venture is. The parties should agree on what is and isn't going to be going through the joint venture. If it turns out to be a very strong business opportunity with a lot of potential for profit, and one party kind of runs with it solo, the other party obviously is going to feel that they were not treated fairly because the opportunity did not run through the joint venture. So all of these things are items that the parties should clearly define and agree to and think about before entering the venture. Finally, there should be thought given to what if the parties do want to terminate or unwind the venture? How would that be handled? Would there be buyout rights? Payments, how do you determine what the value of the venture is? Things like that. So very complicated transactions, oftentimes depending on what the parties want to accomplish, but also very flexible. So joint ventures are very common and they can be very beneficial for the parties, but from a legal perspective, there should be appropriate thought given to defining essentially the relationship at the early stage. All right, moving to the next topic, number 8 of profits interest. Amy Barnes is going to join again for some discussion of the tax impact of profits interest, but let me start by outlining what a profits interest means, and it's oftentimes called a carried interest as well. Growth-oriented companies often need to attract, retain, and incentivize key employees, and various tools are available to them legally. Stock options are a popular tool. Phantom stock plans where a cash amount will be determined by a formula for paying the employee. And profits interests are also options, or are also choices that a company can use if it is a limited liability company or other form of tax partnership to incentivize employees on a favorable basis. So just a basic background of what a profits interest is, it is an actual equity interest in the company, the LLC, that an employee gets. But it doesn't necessarily pay the employee anything unless the company generates operating revenue or growth in the company's underlying value after the interest is granted. So profit interests are eligible to participate in operating earnings, as I mentioned. So if an employee gets, let's say, a 3% profit interest, if the company generates earnings after the issuance of the interest, the employee can participate in cash distributions if the company has it structured that way, where they actually get payments related to the operations. However, if the company ultimately just maintains its original value at the time of the grant themselves with no appreciation in the underlying company's value, then the profits interest holders won't necessarily get any cash on sale of the company because there is no profit generated from the time that they started as an equity holder to the time that the company sold. So it seems to be it's a very fair tool for companies to use because it really requires that the employees come in and help to generate additional value to the company before they get paid anything. But it also has some favorable tax consequences. So Amy, since you're back, tax consequences, the employee can receive the profits interest on a tax-free basis, correct?
Right.
And what's the underlying theory behind that?
Well, so upon receipt, they receive the profits interest. The profits interest are only going to participate in the growth beyond the value as of the date of grant. So they'll only participate above that. So there's no income tax consequence upon receipt. When the profits interests are eventually sold, they should also be able to obtain capital gain treatment, which means a reduced, obviously it's a lower tax rate than an ordinary income treatment would be.
That makes sense. So the employee basically has no tax on grant, which is favorable, and then they could potentially get capital gain treatment in the event of a sale without actually having to pay any money for the capital interest.
Right.
But the downside is if the company doesn't grow and produce actual appreciation in value, they don't get anything.
Right.
So it's fair for both sides.
Right.
What about, I mentioned stock options earlier. How do profits interests compare with stock options?
So profits interests are similar to stock options, where the stock options are granted with the fair market value exercise price as of the date of grant. And the thought there is obviously profits interest, as we said, the owner of the profits interest participates in the growth of the company after the date of grant. But with a stock option with a fair market value exercise price, it's the same concept. that you're going to participate in the growth because you're going to pay the exercise price when the options are when the options are exercised. However, there are some tax benefits to a profits interest that do not exist with the stock options, or do not necessarily exist. So two different types of stock options, one being a non-qualified stock option. The non-qualified stock option, when an individual actually exercises that stock option, the spread at that time, so the fair market value of the stock less the exercise price, is going to be ordinary income. So the higher rate is going to be subject to withholding, it's going to be subject to employment taxes. As we said, with profits interest, that ordinary income piece generally would not exist. Then with incentive stock options, so incentive stock options provide tax favorable treatment as opposed to the non-qualified stock options. And the reason there is because when the incentive stock options are exercised, there is no tax consequences. There's no ordinary income treatment to the spread between the fair market value and the exercise price at that time. In saying that, though, I will note that there may be AMT consequences because that spread, that bargain element, I guess, is going to be treated as a preference item for purposes of the AMT calculations.
For those who don't know, what is AMT?
Alternative minimum tax. So it's another calculation that's going to have to be done under your tax return. For those individuals that are subject to it, this is going to be a preference item in calculating it, so there may be some tax consequences in that regard. But obviously, it's more beneficial than the non-qualified stock options where you have the ordinary income treatment on that spread.
Okay. Well, thanks, Amy. Because time is moving so quickly, we're going to move to our 10th topic, our 9th topic, and that is new market tax credits. Because we're running a little bit short on time, I'm going to try to be very efficient with this particular topic because we do have Alex Virchow coming up to tell us about some thoughts on patents, and I want to make sure to have enough time to hear what Alex has to say. But as a summary, new market tax credits are a very popular source of financing. A lot of people are very interested in hearing about them because they essentially provide a business with the ability to gain access to a funding source on very favorable terms. They're also interesting to lenders such as banks because they can provide the ability for the bank to obtain essentially federal tax credits. So it makes a loan on perhaps some terms that absent the credits it wouldn't normally make, but it receives the benefit of tax credits as part of the overall structure of the transaction. And so the bank is more than happy to participate in the transaction and receive the benefit of the credit. Very high level, and if you have any questions on this, please follow up with me and let me know. But at a very high level, new market tax credits are a program that is, of course, created by the federal government, Congress, and what they do is they provide allocations of tax credits to applicants called allocatees. So there are groups out there oftentimes that are connected with banks, but it doesn't have to be that type of group. But groups out there will apply for and receive allocations of the tax credit. There has been a very in-depth and fairly complicated, frankly, legal structure that's in place to help distribute the credits, so to speak. And what happens is the allocatee receives the credits from the government and has to complete a very detailed application as to what they're planning to do with the credits in order to get the allocation. Once the allocatee has those, they will work with other groups to create basically a new market tax credit investment. And what will happen is there will be an investor that will be part of the investment structure, oftentimes a bank, and the investor will invest into a fund where they will be a partner in essentially a limited liability company or limited partnership and will receive credit as a majority or perhaps 99.99% owner of the fund. So they'll contribute cash or lend cash to the fund, which will be used to actually be lent to or invested in a recipient company called a qualic bead. Qualic bead is kind of a clumsy acronym that's been developed under the New Market Tax Credit Program to basically be a qualified business that's going to end up actually usually borrowing funds under the program. The actual loan that they take on is called a qualic I, a qualified basically low-income investment. So under this program, the summary is that the company that receives the loan is ultimately getting a loan that is in a designated or preferred area of the country as specified under the program. Oftentimes in some kind of zone that there's a policy for trying to increase employment or business activity. And As a result, they received a loan on terms that were more favorable than they normally would be able to get. And the lender, investor, obviously receives tax credits for the trouble of being part of the transaction. So they should be kept in mind, although I will say that there are so many requirements along the program that it's not necessarily as commonplace as people would think to be able to obtain the credit. Okay, moving on to our next topic, our 10th topic, overview of the patent filing process. And for that, we're going to turn to Alex Mirchek, who is in our intellectual property group, and can basically tell us about the patent filing process. This is intended to be a high-level summary, so bear that in mind. Obviously, there's a lot of strategy, both business and technical, that goes into the patent filing process.
Yeah, and kind of to speak to that strategy a little bit at the outset, so patents, specifically and IP more generally, can be thought of as tools that can be used by a company to achieve its business objectives. For example, the patents can be used to help limit the ability of third parties to take business that a company already has. They can be used to help limit the customers of the company from replacing the company as a supplier, and they can also really create risk for third parties that are attempting to enter the company's product space. So with that being said, what you can do is consider the cost both of preparing and filing the patent application and the cost of moving the application through the process at the patent office from application to patent against the potential upside of being able to protect the invention. Now, it's important, and it can be important to consider the patent process, consider the cost, do that calculation early, though. What I mean by early is before public disclosures, sales, offers for sale of the invention. In many jurisdictions, once you offer for sale, sell, or publicly disclose prior to filing a patent application, you're going to be barred from obtaining patent protection. And even in the U.S., while there is a grace period, a year-long grace period from those events, it's very limited, especially under the new law that went into effect in March of last year. It's going to be very important to consider the patent process and consider whether patent protection is right for an invention at the outset. There are several different types of patents: utility patent, design patent, plant patent. Utility patent is generally related to and protects kind of the functionality and the structure of an article, whereas a design patent is going to be directed more towards the ornamental appearance. Both have their place. For utility patents, you're going to make the decision between filing a non-provisional application and a provisional application. Provisional application, while it's generally cheaper to file, it merely acts as a placeholder to kind of get your date in line for your invention. And a non-provisional application will need to be filed within 12 months of filing a provisional application in order to obtain the benefit of the provisional application. The provisional application will never be examined. It's merely buying you that placeholder. In the U.S., a patent provides you the right to prevent others from making, selling, offering for sale your invention. However, U.S. patent doesn't allow you to stop other people from doing those things in other jurisdictions outside the U.S. You have to make a decision jurisdiction by jurisdiction where you want to try and obtain patent protection. The filing for an application in each country has to be done within 12 months of your U.S. filing. However, there is the option to file a Patent Cooperation Treaty application, a PCT application, which essentially buys you 30 months in which to decide where you want to file your application. It can be beneficial because a lot of businesses may not know at the outset which jurisdictions are going to be important for them, where they need to protect their invention. So prior to kind of entering this whole patent application process, patent filing, the whole prosecution, especially if a company is entering a new space, it may make sense to do what we call prior art search, to kind of look and see what else is out there that might either prevent filing of a patent, or obtaining of a patent, or could limit the kind of the scope of patent protection available. It can help to make the decision as to whether it's commercially valuable to pursue patent protection a little bit. Kind of the last note is once you have your patent, there are, for utility patents in the U.S., fees that are going to be due at 4, 8, and 12 years. For design patents, no maintenance fees necessary to keep the patent in force.
Thanks, Alec. Just sort of as a summary from a business perspective, patents obviously can be very critical to protecting a company's value and should be considered, because obviously there's a very technical process, as Alec mentioned, for going through the patent filing process, but there's also oftentimes a strategic decision as to what the best method of protecting company value when it comes to intellectual property should be. So the pros and cons that Alec mentioned of the cost of filing a patent obviously considered against the benefits that would come from that specific type of protection. So thanks again, Alec. And that brings us to our next topic, the 11th topic, and I think we're doing pretty good about being on time. So tax incremental financing grants are a totally obviously different type of category from intellectual property protection. Oftentimes, TIF financing, going back to the concept of, I guess, company financing, often come up in the setting of real estate companies. And essentially what is occurring under a TIF program is a local municipality is trying to essentially promote growth of their tax base within their local jurisdiction. So they're trying to grow business, grow jobs, et cetera. And what happens is, under a TIF program, usually there are different variations of the format for how the process will work, but oftentimes there'll be some kind of grant that will go to a private company for engaging in a development, usually a real estate development of some type. It's not, the situation isn't unique to TIFs, but TIFs are right now a very common example of a grant program. The specific issue that I wanted to talk about today regarding TIFs is that there can be a very difficult tax issue, getting back again to taxes on this issue, with receiving TIF grants. From an economic perspective, it sounds great, and it is. The company, if they do certain things to promote the municipality's job growth or tax base, are going to get free money, basically, which is a great idea. Why does the municipality do this? Well, they do it because with that growth in the business, there's going to be higher taxes paid to the municipality. So that ends up helping the municipality as well. But the issue is, if grants are received by an entity other than a corporation, then the general rule is that they are subject to taxation. So if oftentimes the issue comes up if you have a real estate entity, a development entity that is a limited liability company, that doesn't qualify as a corporation for tax purposes. A lot of times it's going to be a partnership. And absent some special exception, what happens is the grant funds come in and are subject to tax. Seems unfair, and there's some logic to why it is unfair. There's some history behind this. Historically, there were some cases that came out way back when railroads were all the rage, and there were some examples where railroad companies were creating rail lines among cities, and sometimes there would be a situation where a city didn't have rail access, so they weren't able to get access to the U.S. mail as much as they would like. So in some cases, jurisdictions would try to incentivize rail companies to extend rail lines to their cities and do that through some form of grant. And when that issue came up through the courts created a judicial rule that said, well, wait a second, the rail company really isn't benefiting they're benefiting in an ancillary basis by getting these grants, but they're kind of being induced to do something by another party that's not a shareholder that they wouldn't normally do. So it's kind of a unique situation. So they created a special rule where the company would not be taxed. And subsequently, years later, Congress enacted a codification of that rule. They passed a law that tried to preserve that rule, but do it under the statutes rather than under the court-generated law of precedent. And the problem is that when they created that law, they limited it to corporations. Now, there's a lot of debate as to whether they intended to do that, but that's how the statute reads. So there is a question as to whether this was really intended to be a difference, but the IRS takes the position that there is a difference, and they do have the benefit of the statute to support that argument. So oftentimes companies really have to think hard about what to do if they have a project that's going to be getting TIF grants. One possibility is they could just conduct the project through an S corporation or a C corporation. If that's the case, there's typically not a problem. There's some requirements that have to be met, but usually the parties are going to qualify for special treatment where they're not going to be subject to tax on the receipt of the proceeds. However, if the project is, for other reasons, needed to be conducted through a limited liability company or partnership, then in some cases the parties need to consider an alternative to that. And in some cases, companies can consider perhaps having another company, which is a corporation, entering into a TIF development agreement where they'll receive the funds, but then lend them or contribute them to a operating entity, which may be treated as a flow-through entity. There are a lot of elements to consider in considering such a structure, so you should think about it very carefully before doing that and understand all the potential tax issues that are that could come up. But as a sort of a 30,000-foot summary of the matter, there may be some ability to avoid the tax consequences that would require some of the TIF funds essentially having to go to pay taxes, which could be, at ordinary rates, that could be in the 40 to 45% rate. That brings us to our last topic, customer product development and manufacturing agreements. And then after completing this topic, we'll just very quickly see if there are any questions. It looks like we're very close to being on time, but we're not going to have a lot of time for questions. So feel free to reach out after the program with any questions that you may have as well, so that we can take some time to talk about it. But the last topic is customer product development and manufacturing agreement. So this is just a general sort of checklist of ideas to consider for a company that is going to be engaging with in a contract with a customer and should think through some of these terms. General ideas that the agreement should provide a description of the product to be manufactured, order quantities, performance specifications, material requirements, whether the customer can specify private labeling of the product. There can be obviously many different elements to such contracts. Lead times for product orders obviously are going to be critical to both the customer and the manufacturing company as well. Companies should consider whether the supplier is obligated to devote specified resources to develop and deliver the product. This could be a critical product to the customer, and so there could be special requirements along that side to that the manufacturer is subject to. Intellectual property ownership, again, should be clearly defined in the agreement. That Alex could be the first one to tell us that if there's any sensitivity with how intellectual property is used or shared, the agreement should clearly specify the rules for how the parties are going to treat that intellectual property. Customer may be subject to special obligations, perhaps with the order quantity minimums, things like that. There could be special resale restrictions as to where the customer is allowed to sell. Could be territory-based or otherwise. Other items on the checklist here, amount and terms for purchase price obviously is going to be critical. A portion of the purchase price might be subject to prepayment. Perhaps there's a technology that's being developed by a manufacturing company, and essentially the customer is helping to fund the research and development of the technology that's used to manufacture, that's going to be underlying manufacture of the product, or to allow the manufacturer to be able to source the supplies needed for the product. So there could be prepayment with a staged schedule based on milestones achieved. Perhaps the customer gets a discount for participating in such a program. And then obviously delivery terms would be critical as well. Intellectual property checklist, again, patent, trademark, copyright, other intellectual property protection terms, other business terms, non-competition provisions, and non-infringement representations, warranties, and enforcement terms would all be critical. I see that we're very close to the end here. We've just got a minute or two left, so I will find out if there are any questions at this time. Looks like there are no questions at this time, so I'll just put a very brief conclusion here and allow you to get back to your day. Thank you so much for participating in the webinar. I hope that at least one or two of these topics have helped you, and we'll look forward to next year's webinar, which will be the 3rd annual. Also, I look forward to sharing with you some of the business log information. And with that, we'll go ahead and conclude this webinar, and thank you again for joining.